the rules?
As you see fit, madam.
Okay, in brief, we can just
Right,
come. Yeah.
right.
Yes.
We can start, madam.
Yes, sir. Good morning to all. We are going to discuss today on GESTAT procedures. So before that, most of us are aware of the major provision of this appellate tribunal. But just to begin in brief, I thought we'll go through some few of the important provision of appellate tribunal. And we all are aware that this GST Act has also defined the appellate tribunal in section 2, subsection 9 of the CGST Act. And it is a last fact-finding authority. And basically, there was an amendment in 2023. Prior to that, there was an amendment in tribunal, and it was struck down by the Madras High Court, and wherein they have it has read down as an unconstitutional because I think it was contrary to that Article 50, which was providing that state should take steps to separate the judiciary from the executive. So earlier the constitution of the bench was different, and after that amendment in 2023, they have redefined the bench of this principal bench and state benches. And post to this amendment, it is formed by this on the recommendation of the GST Council, but it will be, the date is yet to be notified from the date as may be prescribed. So basically, the appeal will be filed to the GESTAT against this order from the first appellate authority or the revisionary authority, or based on the conduct and examination of this anti-profiteering, which was recently amended in 2024. So these are the orders against which the appeal can be filed to the GESTAT. And section 109 subsection 5 says that in case if there is any one of the issues involved relating to the place of supply, then the matter will be held by the principal bench. So basically the constitution of the bench is that in the case of principal bench, it will be held at New Delhi, and it has a president, judicial member, one technical member, and one state member. And in the case of state benches, it will be the two judicial member and one technical member of center and one technical member of state. So this is post to the amendment. And basically the hearings of the appeal will be made in case if the appeal is having a tax in ITC, fee, fine up to 50 lakhs rupees, and it does not involve any major question of law, then in that case it will be held by a single member bench. And in all other cases, it will be held by one judicial member and one technical member. So these are some brief provisions. And if the members are differing in their opinion on any points, then such members shall state the point that they differ, and the president may refer the case for such hearing. There are brief procedure in this GESTAT rules on this case, but I'm just trying to give in case if there is a difference in the member of a state bench. For example, if it is in Karnataka and we have only one bench, then it can be referred to a state. First, it will be referred within the state bench of same state. And if you don't have any state bench within the same state, then it will be referred to a member of a state bench of another state. And if wherever the appeal was originally, if it is heard by the member of the principal bench to another member from the principal bench, and if it is where no such member is available, then it can be referred to a state bench. And such point or point shall be decided according to the majority opinion, including the opinion of the members who finally heard. So we have some discussion on this. We'll go through when we are going to discuss on the procedures. And qualification, I will not just go into it because it has been defined already. And basically, now coming to this, before going into this, we will be discussing in detail 111 of this GST Act, where the for discharging function will have the same powers as vested in civil court of the Code of Civil Procedure, and they can come out with other functions. We'll go into detail on that aspect also. And basically, Gestat has power to confirm, modify, or annul the orders. They have the power to refer the case back to first appellate authority or revisionary authority or the adjudicating authority with such direction as it may think fit. So remand back is possible with the Gestat. And there is also power given to Gestat to admit the appeal or not if the monetary limit is below 50,000. And subject to that, there is also a circular which is defined on those aspects. And then they can grant up to 3 adjournment. And they also have the power to rectify the orders within 3 months. And that rectification can be made only after giving an opportunity of being heard if there is any enhancement of tax liability. And the time limitations in the appeal provision is 3 months from the date of communications or the date which will be notified. So from that date, based on section 112 subsection 1, they have the time limit of filing the appeal within 3 months. And further condonable period is also 3 months based on section 112 subsection 6 for the taxpayer. And if there's any cross objections, they are supposed to file against the department appeal. The time limit is 45 days of receipt of notice that appeal has been preferred under this section for whole or part of any order. So condonable period of further 45 days for this cross objection is also permissible. Subject to that, there is a sufficient cause for that. So this is the time limit they have specified. And also there is a pre-deposit provisions where they are supposed to deposit the whole 100% of the undisputed tax, that is admitted tax. And if there is any disputed tax, then there is an additional requirement of pre-deposit of 10%, in addition to the amount which is already paid under section 107 subsection 6 for this. And there's a maximum limit of 20 crore under CGST Act and 20 crore under SGST Act. And there's also an amendment to make a mandatory pre-deposit of 10% in case of penalty order, but that is yet to be notified. So these are the certain things. And APL 5 and APL 7, we see that it has to be filed electronically. In APL 5, the appeal has to be filed. An acknowledgement has to be given in APL 2. And manual filing is permissible if only the order in appeal is issued manually. So APL 6 is memorandum of cross objection and APL 7 is the order. So these are the brief provisions before I proceed with the Gestat tools.
I just want to say what we are seeing on the screen is
rules. It is the rules. I thought like
no problem. Done that.
Yeah, before. So
Yeah.
now this Gestat procedure is divided into 15 chapters, which are consisting of various like powers and functions, institution of appeal, cause list, all that. There are various chapters, and we'll try to look into the important chapters, which are which we have to go into depth of that. So before going into this, the notification says that it is based on section 111. The power has been given to the frame these rules for regulating the procedure and functioning of Gestat Tribunal. So before going into this, like whatever we have the issues for each aspect, I thought we will go into depth of that. Now, if you are referring to this definition chapter, the first act itself says that it is referring to only CGST Act or SGST Act. Basically, the issue here is why the IGST Act is not referred or why the Compensation Cess Act is not referred with the first thought which we get when we are reading this rules. So this is the first point of discussion for all of us, like why the IGST Act or Compensation Cess is not referred. If we refer section 20 of the IGST Act, this says that whatever the provision applicable for central or state will be applicable for IGST Act, and similarly for compensation. But should we refer section 20 of IGST Act and says that based on that they have not incorporated the IGST Act and Compensation Act, or Even the IGST Act and Compensation Act should also be referred here. What is the viewpoint of members? Like, is it like, hello,
Thinking,
hello?
I'm just thinking.
Sir, I'm audible, sir.
You're audible, you're
Yeah,
audible.
yeah.
I'm just,
So this is the first point. Any member would like to add something here?
will 20 not cover, madam? Is like 20 covers all those appeal mechanisms. This is part of the, these rules are part of the provisions of the act. So why would it not cover? It would should cover, no, madam?
Yeah, but we have something called as principal bench also, where if there is a matter of place of supply, then it will go to the principal bench. So something, is it not that some provisions are also there in the IGST Act which can be litigated? So why not the IGST Act was referred, or only for procedure we have to refer to the CGST Act?
No, madam. What I'm saying is, see, these rules are under the appeal
CGST.
CGST appellate provisions. So now the appeal provisions are covered under 20. So this being the subset of it, isn't it automatically covered?
Yeah, that was a one thought process, but any member has any other thought on this, like they would have incorporated, or was it not required?
Because these rules are from 112 and 112 is covered in 20. So these rules should also be covered.
Okay.
The same what applies for 107 applies for 112 as well, isn't it? You know, although we
Right.
refer, yeah.
Yeah, but these rules are separately under GST Appellate Tribunal Procedure Rules. So I agree that to the extent of whatever is stated in the CGST, to that extent Section 20 is there. But for this Appellate Tribunal Procedure Rules, they would have also incorporated IGST Act or Compensation Act. That was my thought process.
Because most of the provisions are a part of the CGST Act and which are adopted by the IGST Act. So maybe that could be one of the reasons in my view.
The
Ma'am,
things
can we
are
read this
in-
unless
no.
the context otherwise requires? So act means, so in case of place of provision, the context would move to IGST Act and something like that.
See, to
Yes.
say the context does not require reference to act as defined will
Hmm.
mean that in a particular context in these rules, we'll have to show that they want to deviate from using this definition. You know, that's those instances are generally something which a court will come back and say, this is a situation like that.
Okay, got it, sir.
Is it possible? One possibility is that since IGST relies on appellate mechanism in the CGST Act, there is no need for a reference to IGST Act in the rules. Another could be that simply drafting error of these rules. Which do you think is more likely?
I think drafting was my thought, sir.
ಅದೇ ಈ ಬಡ್ಡಿ ಮಕ್ಕಳಿಗೆ ಬರೆಯಕ್ ಬರಲ್ಲ ಮೇಡಮ್.
ಇಲ್ಲ. There is some reason, but
ಇಲ್ಲ, don't give them too much credit. I don't know, this is all given to some 12th standard student to copy paste from somewhere and they have
Yes.
drafted these rules.
Yes, sir.
ಅಷ್ಟೊಂದು interpretation ಮಾಡೋದು ಬೇಡ.
Okay, sir. Just a thought, I thought, just for discussion. Yeah, then we have this adjudicating authority, which is already defined in the CGST Act. And wherever it is applicable, they have just referred here. And here appellate tribunal is also defined in CGST Act, and also they have defined in this rules, which they says that it is established under 109 of the GST Act. The very important part is because in this rules, we are saying that there are very wide powers which are given to an authorized representative in relation to any proceedings before the appellate tribunal. So wherever, if it is a certified copy or wherever they have defined the procedure for filing the appeal, they have also referred the reference of an authorized representative, which was unlikely in the CESTAT or KVAT CAT tribunals, sir. So that is the one important aspect I'm able to see for the authorized representative. So, like if we see the definition of certified copy also, we are able to see that it means the original copy of the order of the documents received by the party or copy duly authenticated by concern, or a copy of duly, even if it is authenticated by the authorized representative of the appellant or respondent, even that is treated as certified copy. And even I'm able to see in Rule 22 also, which I'll just bring out just for our discussion, sir. Like, if I say, they say that it has to be signed by the authorized representative. One second. So, only my issue here is like they're asking for even the authorized representative has been given the power to sign the appeal proceedings. So that is what I just want to bring out the point here. So today, if you are able to see, sir, most of the time we are only signing the power of attorney or vakaltnama, but we are not signing all the appeal papers. But today the power has been given through just power saying that even it can be signed by an authorized representative. And second point is the authorized representative has already been defined in the CGST Act, but specifically they have brought a person in relation to any proceeding is a person duly appointed by central government or state government. And also they have stated a person authorized in writing or through a vakaltnama duly stamped by a party to present his case before the appellate tribunal as provided under 116. So basically here the point is that how to take it forward, like in few of the cases, should he be because it says that it should be a practicing CA. They have used a word in 116, it should be a practicing CA. So here the issue is like how shall we what shall be the power of the authorized representative for the appellate procedure, sir? Because like if we read few of the papers, so what precautions we have to take for authenticating the documents or authenticating the appeal file or giving us a certified copy is because this power was not there to my knowledge for the authorized representative, which has been added in GST tribunal rules.
My suggestion, in APL 1, authorized signatory name must not be incorporated at all.
Okay.
You know, we are also publicity hungry, that everywhere we will want our name. Even if assessee does not come to office, we will only sign the appeal papers and file it.
Yes, sir.
You senior advocates are getting summons. So you please control all the enthusiasm. Let assessee sign all papers, file the appeal. After the appeal is filed, in 1 month, you get the authorization ready and submit it in the tribunal when you are going for hearing. There is no need to take a leadership role in signing papers. There is no protection for chartered accountants when they have this kind of enthusiasm. Please don't sign any papers. Please don't sign appeal memo. Let the client take responsibility for signing. We can only assist in filing the appeal. At the time of hearing, we will act on instructions given by the client. The authorship of all the grounds, all the positions taken should solely rest with the taxpayer. What does it take for a taxpayer to say, I never told my authorized representative to tell like this? You know, all the instructions given by clients, we don't have documentation. Our audit colleagues don't have adequate documentation. We will not have documentation. Please don't sign. this power given to sign is a dangerous power. It is there, and if you don't take the exercise those powers, you are in a better position. I'll just give you a parallel. Take an example, a client is in jail. A client is in jail, an application has to be filed in court. In those cases, even without the client's signature, the advocate can file a memo of appearance and move an application in court. Somebody, I told you, somebody has copied provisions from High Court procedure rules and incorporated it here, thinking that it looks fancy. Please don't use this. I think this is misplaced. Historically, we have never had this level of power on the authorized representative. Now, without any background, it is suddenly finding a mention here. Therefore, this is another instance of drafting oversight. Let's not get carried away with this.
Sir, here in the certified copy definition, it is not specified that appellant himself can sign. So,
No, no, no.
Mm.
What the principal cannot do, the agent can never do. This certified copy, you know, previously how it started in Rule 108, where they said you had to get a certified copy from department. Department was refusing to give certified copy. Then there are decisions to say self-certified is sufficient. Then they removed the certified copy from the rule itself to say that self-certified is sufficient. Now what happened? How come certified by author has entered the tribunal procedure rules? You please see the rule. What the rule? 108, 109 in the CGST rules.
yes, sir.
So therefore, how can the procedure rules be contrary to the CGST rules?
And there are few of the rules, sir, which are contradicting, like even, yes, sir. And even if we read in Rule 20, sir, here also, like what I was saying is, here also they have said every form of appeal or application or cross objection shall be signed and verified by the appellant or applicant or respondent or the authorized representative. And the appellant or the applicant or the authorized shall certify as true copy the documents produced before the appellate tribunal. So this is what I was just trying to highlight on that point, sir. So as you said, we have to be little cautious. We should not take that responsibility of signing all that appeal documents, especially, and it has to be signed by the appellant or the respondent as the case may be.
Correct, correct. See,
Yeah.
why we want our name to go into the APL 5 form is because when the cause list is published, our name will appear in the cause list and we will become world famous. All these cheap thrills we must let go of.
Yes,
That is not the way to become world famous.
yes.
So therefore, we should be very cautious in signing. I have seen appeal papers signed by the authorized representative. Client has forgotten to sign. Okay, proceed, madam.
Yes. And here they have referred, there are CGST Act, this is fine, form are, there are specified form which are prescribed under these rules also. We'll just take it up detail. And they also defined the GSTAT portal, means web portal as may be specified by an order by the president for the functioning of the appellate tribunal. So to the extent of my knowledge on section 148, where they have defined common portal. So I think that excludes the GSTAT portal. So I think this is an independent portal which will be framed under this GSTAT procedures, and accordingly the application will be filed. But I think so common portal is not including the GSTAT portal. So this will be a different web portal as may be specified by an order. So we have to wait and see how it is going to get function. I think on testing mode they came out for a few days and again it got disappeared. So this is what it is in the testing mode to the information what I have on GSTAT portals.
So just one point here, sir.
Yeah.
Like Rule 108 uses self-certified, Rule 110 uses certified copy, sir. So they can't reject a copy which is signed by the appellant himself under Rule 110, no, sir?
ಇಲ್ಲಮ್ಮ ಇದೆಲ್ಲ ರೂಲ್ಸ್ ಅರ್ಜೆಂಟ್ ಅಲ್ಲಿ ಏನೋ ಮಾಡವ್ರೆ ಬರ್ಲಿ ಟ್ರಿಬ್ಯುನಲ್ ಪರಿಷತ್ಗೆ ಫೈನಲ್ ಎಕ್ಸಾಮ್ ಮುಂಚೆ ಎಲ್ಲ ಕರೆಕ್ಟ್ ಆಗಿ ಓದ್ಬಿಡ್ತಾರೆ ಬಿಡಿ.
Okay, sir. Okay.
They have to
Okay.
notify the rules based on
Mm.
some thinking at that point. They have notified at that time when they made the amendment to the rules. The certified copy became a big problem. Then they amended the rule to say that self-certified okay. They forgot about the corresponding rule in the tribunal. In tribunal ನ ಫಾರ್ಮ್ ಆಗಿಲ್ಲ ಯಾಕೆ ಅದೆಲ್ಲ ಆಮೇಲೆ ಮಾಡೋಣ.
Okay, sir. Okay.
Sir, in one of the rule, they have used attested copy also, sir. Attested copy or certified copy. Just in rule 21, sir, I think somewhere I was reading, so I was just trying to understand what is that attested copy also like. I will just
Copy.
copy paste, that's what. So that is one thing. Yes. Yeah. So we'll come to the definition again. So form will read. So this is fine. So this just at portal we have to wait and see. And this is also interlocutory application. It is an application in any appeal already instituted in such appellate tribunal other than a proceeding. So it is similar to what we had earlier in SESTAT and given.
I think that portal registration is open just as a registration. Anyone has tried that?
Actually, I tried, but it was not functioning when I heard that it was there. So I tried, but it was not functioning when I tried again with that link. So it was showing error. If anybody has tried, yeah.
Venu, sir?
No, I have not.
So basically it is appellant's registration portal only, no?
Yeah, as on date, they have said that you have to register with your username and password. So I saw somewhere that it was functioning, but when I tried, it was showing an error. So I think it was just taken for testing mode, I think. Yeah.
Oh.
Yeah. Then member means a member of the appellate tribunal and includes the president and vice president. If we read the section and rules, sir, there is no reference of vice president as such, but here we are also able to see that there is a reference of vice president which is given. This is a one thing. Then party means a person who prefers an appeal on an application before the appellate tribunal and includes respondent. And in few of the rules, we are able to see that they are giving the reference of party. And few of the places they are giving the reference as an applicant or respondent, something. So this word is not commonly used in all the rules. And we have to read party as any person who is appealing, who is filing an appeal. Either it can be a taxpayer or it can be a department also. Then specified as specified by or under this rules. So president of the appellate tribunal as per 109. Then so they should also define vice president, what I think. Then principal bench, already we have discussed, constituted in accordance with subsection 3. One thought here we have, sir, like principal bench, they say that if any of one of the issue in the order is pertaining to the place of supply, then the whole order will be referred to the principal bench. So even on other issues also, the principal bench will decide, or again, it will be given to a state bench. So I think it will be, section says that it will be decided by principal bench only at New Delhi.
Yeah, all the issues will go there. Any thoughts on how strategically not to agitate POS so that the appeal does not go to principal bench, or how to make a POS an issue so that the appeal goes to principal bench?
Is it something like I in lieu of C&S or something, can we think? Because it will be either on the levy or it will be either on the credit partners.
Section
True.
77 can we use, sir?
How?
No, that is not POS, no?
Oh.
That is for wrong payment of tax.
How do you
Okay.
suppose we use that?
I mean, again, it goes back to the facts to ascertain if we can do that or not.
Hmm.
Sir, in case of assumption-based tax demands,
Hmm.
where they simply say it is 18% CGST as GST, we can do that as an POS-based issue and we can take it to principal bench.
Evaluate it should be whether there are possibilities, because we cannot create an issue. We cannot create a POS issue, but many times POS is part of the issue itself.
Sir, MOV cases, sir, where they give the transaction is interstate, but they issue temporary registration and put up
So
with
then,
the
I just turned in, then it will.
then is POS the issue, or is the
registration.
penalty the issue?
Mm.
Documentation.
Look at this, because this is definitely going to be something that will be tested. And whenever there is doubt, principal bench may not say we will not entertain this.
Sir, intermediary cases can come here, na, sir.
Possible.
Mm.
Possible. So there are many issues. If it's not just an IGST demand case,
Yeah.
it can be a case of POS. If IGST demand is there, but POS is not the issue, still state can take it. Because they're not saying that all IGST matters will go to principal bench. They're saying only POS matters will go to principal.
So IGST with place of supply Karnataka will still be subject matter of Karnataka. Yeah.
Yeah.
Madam, interlocutory application, shall we spend some time on it or you are reserving it for later discussion?
Whatever. Because I think we have to
I
check.
mean, definition. Because
Sir.
IA is a separate chapter.
Yes, sir. We'll go later. And here they have also defined all this SGST, UT, state bench, all that in accordance with. Then vice president means vice president of the state benches as per subsection 7 of 109 of CGST Act. So this vice president we have to refer only for state benches and not for the principal bench. But here I was reading member means member of appellate tribunal and includes the president and vice president. So this appellate tribunal here, I think we have to read only for state benches, right? So it is not for principal bench. So these are the brief definitions, and wherever we can refer the definition from the act or the rules as the case may be. Now, this is little more important to understand the powers and functions of the tribunal. So very important is first aspect is on the computation of time period. Let us spend some time on that. Here they are trying to say that where a period is prescribed by the act or the rules or these rules or under any other law or is fixed by the appellate tribunal for doing any act, in computing the time, the day from which the said period is to be reckoned shall be excluded. And if the last day expires on a day when the office of the when the appellate tribunal is closed, that day and any succeeding day or days on which the appellate tribunal remain closed shall also be excluded.
కింద సరోజాకి ఇచ్చేసాయి కింద ఉండి గేట్
Venu sir.
సారీ
Saroja ఏమంటా?
లేదు
Go on.
Yes, sir. So here the issue is whether this computation of time period is it for manual appeal or the online appeal. This is the first part. And second point is they are saying a day when the office of the tribunal is closed. So if we read the other rules, the working day of the tribunal will be for 5 days as to the extent what I understand. So if it is falling on Saturday or Sunday, can we take the benefit of that and file it on Monday? This is a one part. Because specifically they say that if the last day expires on a day when the office of the tribunal is closed. This is the second discussion. And third, they say that in computing the time, the day from which the set period is to be reckoned shall be excluded, and if the last day is on close, any succeeding day or days on which the remain closed shall also be excluded. So is it something we can look into that, sir? Because
Madam, one ನಿಮಿಷ. Appeal has to be filed online, huh?
yes, sir, that is what I understand.
What is Saturday, Sunday public holiday problem? Why is this rule there?
Yes, sir, that's what. Because if
Then
it is on, yes, sir.
ಆನ್ಲೈನ್ ನಾವು ರಾತ್ರಿನೇ ಫೈಲ್ ಮಾಡೋದು ಟ್ಯಾಕ್ಸ್ ಅಭ್ಯಾಸ. Here is a question. Now tell me, if we filed it in the night online, then tomorrow that day was a public holiday. Will this become a point of dispute for dismissal of the appeal based on the procedure rules?
Yeah. I think this is not required, sir, for me,
Yeah,
according to me.
only manual ಅದೊಂದ್
Yeah.
ಅದ್ರಲ್ಲಿ ಪ್ರೊವಿಷನ್ ಇದೆಯಲ್ಲ ಸರ್, ಮ್ಯಾನ್ಯುಯಲ್ ಆರ್ಡರ್ಸ್ ಮಾಡಿದ್ರೆ ಮ್ಯಾನ್ಯುಯಲ್ ಅಪೀಲ್ ಅಂತ ಅದಕ್ ಮಾತ್ರ ಅನ್ವಯಿಸುತ್ತೆ ಸರ್.
But the GST-AT portal is there. Is it possible for a manual appeal? We have the rule for a transitionary period. You understand?
Yes, sir.
So, madam, as we are discussing, you please make note which are the rules that have to be deleted from this book.
Yes, sir.
Continue, madam.
Yes, sir. And only one more point, this is to be deleted, and also one more, they have also referred under any other law. So this is also one more discussion point. Anyway, we are not considering this rule because this is not applicable for online appeals. So this is then the next part is format of order or direction or ruling. So whatever is every ruling, whatever is issued by this appellate tribunal in the name of president or the member and shall be signed by the registrar or any officer on behalf of by the president with the day, month, year signing and shall be sealed with the official seal of the appellate tribunal where physical copy is issued. So they are just saying how should be the format of order which has been issued by the appellate tribunal and it has to be sealed and signed. So I don't think anything discussion required in this, sir, from my side. Yeah.
Again, this is only for the physical copy, no? If it is uploaded online,
Even that has to be digitally signed. No?
digitally signed, yeah.
Yeah. But interestingly, sir, in the whole rule, I was able to see that I did not find anything where they have given a reference of information technology will override all other, something I couldn't make much on that, sir. Or on digital signature part also, I have not looked into any of the provisions, sir. That is, yeah, sir. Now, next is official seal of the appellate tribunal. The official seal and emblem shall be such as the president. So this is fine. This way. The custody of the records. Basically, here they are saying that they have all the custody of the records of the appellate tribunal, and no record or document filed in any case shall be allowed to be taken out of the appellate tribunal without the leave of the appellate tribunal. So whatever existing procedure is there, I think same thing they are saying. If you want a special copy of that, then you have to make a application for that document, and they may allow any other officer of the appellate tribunal to remove any official paper or record from the appellate tribunal. Only with the permission, I think we can have access to the document. Otherwise, whatever the document has been filed, we don't have access to that record.
What is the purpose of this rule, madam?
I think basically just they want to access the document to further analyze the case, sir. I think that is
No, in the procedure rules, what is the purpose of this?
I think they are giving the power of the registrar also in this, not only along with the appellate tribunal. A few of the things they are also trying to give, say what is the power of the registrar. So here they are just trying to.
1 minute. The registry will have a detailed manual of instructions that they will follow internally, what dress the registrar will wear, how he will salute the bench, how they will sit, how will they address the bench. They'll have a manual, correct, no?
Yes,
Like today we have the stat manual.
Yes, sir.
Matters which are relating to indoor management of the tribunal registry. Why is that part of the taxpayers' procedure rules?
Yes.
You understand?
Yes, I got it, sir, actually.
Copy paste ಮಾಡುವಾಗ ಎಲ್ಲ ತಂದು 124 rules ಮಾಡ್ಬಿಟ್ಟವ್ರೆ. Why is this relevant? President will sit in a bigger chair, other members will sit in smaller chair, 3 chairs, red color upholstery. These are all not relevant. It is important for the tribunal to function, but it is not part of the rules, no? Now ಕೂತ್ಕೊಂಡು discuss ಮಾಡ್ತಾ ಇದೀವಿ.
Howದು, sir. I think from rule 4 to rule 7, all are the functions of the tribunal only, like how is the sitting, what are the hours they have to sit, what is the working hours. I think till the rule 9, it is a function of the registry, appellate tribunal. And I think from 10, we can look for our purpose, sir.
ಮಾಡೋದು.
So this all working hours, what is the sitting, these all are applicable to tribunal and not to the tax. Then now coming to this inherent power, where they are just trying to say that they have inherent power to make any such order or any give direction as may be necessary for meeting the ends of justice or to prevent abuse of the process of the appellate tribunal. So I'm just trying to understand here, is this something which is not defined in the CGST rules, sir?
Of course not.
Yeah.
Of course not.
And if we read 111 of the CGST Act, they say that they can formulate their own procedures and rules. So something they are bringing out from 111 subsection 1, sir, here something, because
No, but see, here they are not framing those inherent powers. They are only saying that inherent powers is there, which is already set in the Act. The Act should say certain things. Rules should say certain things. Procedure rules should say some things. Everybody is stamping on each other's toes here.
Correct. So this is something I think it has to be reframed.
Relevant.
Yeah.
Good
Then
thing.
even this calendar of working days, whatever is holidays and whatever, that is also given. I think this is also again applicable to the appellate tribunal and not to the taxpayer. And 12 might be is applicable to us to understand if there is any urgent matter before 12 noon shall be listed before the appellate tribunal on the following working day if it is complete in all respect. And as provided in these rules and in exceptional cases, it may be received after 12 noon but before 3 p.m. for listing on the following day with the specific permission of the appellate tribunal or president.
1 minute. Now, see, unlike the civil cases, in civil cases, you file it and then you make an application before court asking the court to list the matter. You understand?
Yes, sir, early hearing.
And early hearing is an application. This is called moving the matter. They want to move the matter to be heard when both parties are ready. You consult with each other, you move the matter. In tribunal, moving the matter procedure is not there. We'll file the appeal, it will come in 1 year or 10 years, we only have to keep waiting. If we want the matter to be heard, we have to file only an early hearing application. Early hearing applications that are allowed are also not heard early. There is a separate cause list created, and then it is listed according to tribunal's decision. This listing of cases file before 12 o'clock, High Court rules that they have copied.
Yes, sir.
This
Correct.
procedure is not there. Where is the procedure in the Act? I file an appeal, then everybody will move the matter for early hearing. For everyone, it is important. Correct, no? So this
Yes,
is
sir.
also redundant here.
Yes, sir. And they have specifically used the word urgent matter. So I'm not able to think also which will be an urgent matter because this will be filed only against appellate tribunal, first appellate order or revisionary order. So it's not a first authority, na, sir, where it will be filed.
ಏನು ಅರ್ಜೆಂಟ್ ಇಲ್ಲ ಇದೆಲ್ಲ ಹೈಕೋರ್ಟ್ ಇಂದ
ಇದು ಹೈಕೋರ್ಟ್.
ಅವ್ರು ಸತ್ತೋದ್ರು, ಬಿಲ್ಡಿಂಗ್ ಡ್ಯಾಮೇಜ್ ಆಗೋಯ್ತು, ಬುಲ್ಡೋಸರ್ ತಗೊಂಡ್ ಬಂದ್ಬಿಟ್ಟಿದ್ದಾರೆ.
Yeah. So that's what I was. For tax matters, I don't think so. Something will be very urgent as such, which is specified here. Then power to exempt may on sufficient cause being shown exempt the parties from compliance with any requirement of these rules and may give such direction in matters of practice and procedure as it may consider just and expedient on the application mode in this behalf to render the substantial justice. So again, this in matters of practice and procedure is also a very wide term, sir, which they have tried to say. And I don't know from where they got this power. Even 111 subsection 2 also has not been given that power, sir, I think.
Correct.
So this was the one aspect here. And then now coming to this 14, where the appellate tribunal may extend the time appointed by these rules or fixed by any order for doing any act or taking any proceeding upon if any as the justice of the case may require and any extension may be ordered. Although the application for the same is not made until the expiration of the time appointed or allowed. So I think on their own also they can extend the time limit, na, sir?
How, madam?
Because extend the time appointed by these rules or fixed by any order or doing any act upon
But-
such.
Which is the step for which a time is prescribed by these rules, and which is that rule, that time they are going to extend? All time limit is prescribed by 112,
Hmm.
which means there is no power of extending time.
Hmm.
It is different from granting adjournment.
Yeah.
I
I was
but-
reading this as an adjournment, sir. I think this is not an
Okay.
adjournment, yeah. I was reading this as an adjournment on the basis that in case if the appellant or authorized representative has not represented, then they on their own they can extend the time. Was my thought process. Though there is a provision for ex parte order also, like wherever they have not represented, they have the power.
We'll come to that.
Yeah, we'll come to that later. But this I was reading for adjournment, sir. That was my thought. But I'll just read.
No, we have to keep in mind that adjournment is with prejudice to the other side,
Hmm,
and other side can have objections now.
Okay.
So they can't routinely give this.
Okay. That's why they have used as may extend the time. So I think this is something you have to look. Yes.
That power to exempt is again application specific, sir,
Mm-mm.
and not class specific and all. That power is not.
I don't know which is the class you're referring to.
I mean, if they want to make it like to a specific class of registered persons, that is not possible. It is only for the specific application made by the applicant, is it, sir? How, I mean, practical utility of this power, sir?
ಮೇಡಮ್ ಇದು ಎಲ್ಲಿಂದ ಕಾಪಿ ಪೇಸ್ಟ್ ಮಾಡೋಣ ಅಂತ ಹೇಳ್ತಾ ಇದೀವಿ, ಅದ್ರ ಮೇಲೆ ಏನಾರ ರಿಸರ್ಚ್ ಮಾಡೋದು.
Okay, okay.
Again, 15 we are skipping because it is all giving the powers and function of the registrar. So that I'm not looking into that. Then only one point I was having, sir, when I was reading this registrar power, receive application for fresh summons or notice, and regarding something I couldn't get few of the things, short date summons and notices, because I was not able to connect this except 111 subsection 2 where they have the power to issue summons, but this I was not able to connect with that because that power is not with the registrar.
ಇಲ್ಲ ಕಾಪಿ ಪೇಸ್ಟ್.
So this is also all irrelevant, sir.
This is the powers of High Court
High Court.
registrar,
Yes.
Registrar General of the High Court. ಹಂಗೆ ಹೇಳಿಸ್ಬಿಟ್ಟವ್ರೆ.
Yes, sorry, sir, there is a special power of adjournment. So shall be sought before the consentment, and in extraordinary circumstances, the registrar may, if so directed by the appellate tribunal in chambers, at any time adjourn any matter and lay the same before the appellate. So I think there is a special power. So this 14 is different. Then this is rule 17. Again, I will not go into that because again it is what is the power of the president in case of state benches. All that has been given, so I will not go much into that. Now the most important is 18, where they have tried to say, and if you read sir 18, here they are trying to say an appeal to the shall be filed online on the Justrat portal in form prescribed under the rules and shall contain the following details. So first important point, they say that the cause title should be Justrat Appellate Tribunal and all set out the proceedings or order of the against which it is preferred. This is the common procedure which we follow. So it will be Justrat procedure. Now it will be divided into paragraphs and shall be numbered consequently, and each paragraph shall contain as may be a subtle fact or allegation or point. So here they are coming out with the procedure for drafting the appeal. And this was not there, like to the extent what I understand, sir, it has to be divided into paragraphs and it has to be numbered sequentially. That was not mandatory earlier, but now they have made it as it should be numbered consequently. And each paragraph shall contain as nearly as may be a separate fact or allegation or point. So each fact, each allegation has to be numbered separately. That is what they are trying to highlight. And even the paragraphs which are referred in for defining the facts also should be numbered sequentially. Only the issue we are having is this is applicable not only for the facts, even I think this is applicable even for the grounds of appeal also. Because here they are just trying to point out each paragraph shall contain as nearly as may be a separate fact or allegation or point. So here they are not referred as ground as such. So is it only for the facts or is it applicable even for the grounds of appeal? To what extent I understand that even it should be applicable for grounds of appeal also.
You're right.
Yeah. Then next we are coming with all these details which we have to file in APL file, all that full. Only this parentage was a thought to be is it, I think that will be only applicable in the case of individuals or as the case may be, because somebody like if he has authorized for that appeal on behalf of the successor or something kind of that. Because this word we have not applied for our first appeal. We are just trying to give the full name and address, but parentage also, like how you are you parentage is the word what I am
No,
trying
son
to.
of daughter of Madhu.
Son and daughter, which we try to use it for many instances. So, but that will be only in the case of individuals, no, sir? Like because company and all.
You're
Only.
right.
So that is one thing. And GST and description of each party address, whatever is there, shall be set out at the beginning of the appeal and need not be repeated in the subsequent proceedings in the same appeal. So brief details has to be given. Then respondent, appellant, whatever we just try to add here. Then next is the name of the party shall be numbered consequently, and a separate line should be allotted to the name and description of each party, and this number shall not be changed. And in the event of the death of a party during the pendency of the appeal, his legal heirs or representative, as the case may be, if more than one, shall be shown by the sub numbers. So here the one issue what we are trying to understand is this is number of parties shall be sequent, like if it is 4%, 5%, all that has to be like if the parties are 4 to 5, then it has to be consequently numbered. But only the issue here is in the case of death of a party during the pendency of the appeal, how can it will be shown by his legal heirs? Because I think the proceedings will be concluded and again it has to be filed by the legal heir, sir.
Correct, correct. See, every appellant has to file a separate appeal. It's not possible for 4 people, company and 3 directors cannot file a single appeal. Those who don't have GST number have to get a temporary number and file an appeal. So therefore, this is redundant, isn't it? You have to name the parties
Yes.
1, 2, 3, 4.
Yes,
Because
sir.
appeal is the respondent is always commissioner. Appellant is one person. One appeal for company, one appeal for director. So therefore, where is the question of numbering?
And even if it is online also, I don't know how it will be, sir. Like I'm just
ಇಲ್ಲಿ
thinking.
ಬಿಡಿ ಮೇಡಮ್ ಟೆನ್ಷನ್ ತಗೋಬೇಡಿ ಗೊತ್ತಲ್ಲ
ಅದೇ.
ಕಾಪಿ ಮಾಡೋರೆ.
Yeah. Now let us come to the.
Sub rule 3 ಹೇಳ್ತಾರೆ common appeals and joint appeals are not allowable ಅಂತಾನೆ
Yeah,
ಹೇಳಿದ್ರು.
we'll come to that. We'll come to that. Just we were on that point. We'll come to that also. Because here they have given separate scenarios, like what I understand is, like if it is a single appeal, right? Then they are just trying to say that if it is impugned order in appeal has been passed with reference to more than one orders in appeal, then the prescribed as per shall be many as the number of orders in original. So one appeal, one order, like. So if you are having one order, then it will be one appeal against it. So if it is a order in appeal, this is fine, because if there are multiple orders, then I understand that it will be a multiple appeal will be filed. But here the issue is in case it is in respect of more than one person, then as sir was saying, each person is required to file a separate appeal and common appeal or joint appeal shall not be entertained. So this is the point that sir is trying to highlight. But the problem is we are able to see that in few of the instances, there is a common order, sir. But there are multiple DRC-7 which are being issued. So in those scenario, I think we have to look whether we have to file a separate appeal or we have.
one ನಿಮಿಷ.
Sir.
We'll start with what is happening now. There is one SCN for 5 years. There are 5 DRC-7s.
Yes, sir.
How many APL-1 we are filed?
5.
5. 5 APL-1 will end with 5 APL-4.
Yes, sir.
Now they are saying that number of appeals to be filed in tribunal is based on number of order in original.
Hmm.
So it is not per show cause notice, per order in original. So per
Hmm.
DRC 7,
Hmm.
if for any reason
Hmm.
they have given only one DRC 7 for 5 years,
Hmm.
we cannot split that.
Yeah, one appeal only in that case.
But actually, practically what will happen is, since the appeal to tribunal is against APL 4,
Hmm.
we may not be at liberty to bunch APL 4s
Hmm.
or split APL 4s.
Hmm.
So for every APL 4, we have to file one appeal, whether it's coming from revisionary authority or from first appellate authority.
Hmm. Hmm.
See, everyone will take cue from the previous stage. If 5 DRC 7 is there, there will be 5 APL 4 because there will be 5 APL 1.
Hmm. Yes,
That's
sir. Okay, sir.
Sir, but impugned order will be common on one single order, no, sir? So,
The order impugned is the order of revisionary authority or the first appellate authority.
sir, in the example you took, like single show cause notice, single order in original, multiple DRC 7s year-wise.
Correct.
Uh,
So the order impugned is the order at large before the tribunal. The order at large before the tribunal is the first appeal order.
okay, sir.
To impugn is to attack. Okay.
Mm, mm.
Which is the order you are attacking?
OIA.
That's all.
Mm. So,
Either
we
again
have
confusion.
to,
Either again confusion. What's the confusion?
nothing, sir. Illi order in original anta ittala, sir, word. And it doesn't even refer about the electronic summary thereof. That is the confusion, sir. Ashta.
ಏನಿಲ್ಲ ಸರಿ ಹೋಗು don't. Number of APL 4 will decide number of APL 5.
Thank you, sir.
Madam ಮುಂದಕ್ಕೆ.
Yes, sir. Then again, they have come out with this manual, I think, sir, because here they are saying the officer shall endorse on every form of appeal on the date on which it is presented to have been presented and shall sign the endorsement if the appeal is filed manually. So there is something wherever manual appeal is filed, then they have to endorse those documents. Now, next is on this contents of an appeal form. They have just tried to give out that it should be concise and under distinct head. It shall be numbered consecutively and shall be typed in double space of the paper. Basically, I'm just trying to understand, sir, that here they are trying to bring out that it should be on the A4 size. But whereas we are always seen that legal size papers are used for appeal. But here they have specifically said that it should be typed neatly in double spacing on the A4 side paper. And the same shall be duly paged, indexed, and tagged firmly with the form of appealing separate folder. And every form of appeal, which we have already discussed, that it shall be signed and verified. It's not only signed, it should be verified by the applicant or applicant or respondent or the authorized representative. As we have already discussed on this signature part, but only thing is this is specific. This is a change from this, what I am trying to understand, that they are trying to bring out A4 size in lieu of legal size paper. And there should be double space of the paper. They have not spoken on font, I think, sir, which font should be used. I think they would have bring out that also, like Times Roman or something, which would have brought an uniform for filing that appeal. That was missing in font. Which font should be used when you are typing on this part?
Right.
Yeah. Then they've also given the reference of documents which are required to accompany this form of appeal. So here just trying to say that certified copy of this order should be enclosed, and whichever the all RUD documents, that is all the relevant documents which are relied upon, should be enclosed. And also they are also asking to refer the challan of fees also. Now, whatever the documents we are relying for filing the appeal, all has to be enclosed along with this appeal. Only what I was just trying to say here is that the copy of the order appealed again shall be attested copy instead of a certified copy. So I think for the department appeal, they are trying to give a reference of an attested copy, sir. So this was one more which I was just trying to refer earlier. So this is what is given, sir, here. So I think this is a general procedure which we use it, similar it is, only few terms which we are not able to understand this kind of, this is not defined also. So I think it is more or less a kind of certified copy as such, I believe. And it also has to enclose along with the fees as specified in sub-rule 5 of rule 110 of the rules. So there is a fee which has been specified here. I'll just go to that schedule, sir. Just a thought on that for this. So here they are just trying to say that there is a fees which has been specified as rule 67, that is application for inspection of records is 5,000, and 118 is wherever IA we are filing, the fees is 5,000. And whatever has been specified here in gestate, that is, I think 25,000. No? Yeah, it is 25,000. And application under the any other provision is 5,000. And if you want to obtain any copy of order, 5 rupees per page. Only here, what I am trying to understand is rule 1110 has specified some limit, but is it consolidatedly applicable to, because here they are saying CGST, SGST and UT. So should we consolidate the amount which is given in CGST, SGST, or will it be a one amount which has been specified in rule 110 sub rule 5, sir?
I think it will be as per rule 110.
Hmm.
That's all.
So it should
One-
not be like plus, right, sir? It will be only one, whatever is given in CGST. Because that's what in that sheet now they have used that. So that's why I got, otherwise if they would have just used 110.5 of CGST, that was suffice, but they have also referred SGST. So that was the reason I got it out.
But see, SGST also will have rules, no?
Yes, also will have. So for example, if it is 25 in CGST, should I say 25 plus 25, or it is only
Correct.
so that was,
Yes.
yes. Then where are-
IGST will be double.
yes. So, or is it the one? So that is, but it will be little costly affair, I felt, sir. It should be reduced what I felt looking at. Then,
No,
yes,
one minute. Why will it be costly? Suppose that demand is 50,000 rupees. What
Huh.
will be the fees?
it will be, I think, minimum 5,000, sir. Minimum.
No.
Sir?
Let's see 110.
1 second. 110 sub rule 5. 1 second.
1,000 for every 1 lakh.
Yes, sir.
So 50,000 rupees is the total dispute.
Huh.
We'll pay only 1,000.
Yes, sir. No, if it is wherever the huge is there, what I'm trying to say that if it is say 1 lakh for each 5,000, 1,000.
25,000. Suppose 100 crore demand.
25,000.
25,000.
So 25 plus 25, I'm saying like 25.
So it will not become costly for the litigant
Hmm.
who is having 100 crore demand. And for poor fellow, he has 2,000 rupees. Anyway, that chartered account only will pay.
No, but that's what I was thinking, that it should be reduced. What I was thinking, sir.
I mean, how much it should be reduced to? Somebody who's going to tribunal, 2,000 rupees also he will not pay.
Like today, if we advance ruling also, if we are able to see, they are collecting 5,000 plus 5,000. So with that reference, I was also thinking that here also they might collect because they have both state and center here also. So if it is that, then 25 plus 25. So I think 5 plus 5 was more better than this 25 plus 25, sir, with irrespective of quantum of tax liability.
No, but who are you speaking for? You're speaking for somebody with 100 crore liability or with 50,000 rupees liability?
It can be anything, na, sir.
Well, 100 crore ಇರೋನ್ಗೆ what is 25,000?
For 100 crore, it may not make difference, sir, but I'm just talking on this taxpayers who are having like many appeals we
Give me
have.
example. Give me example.
Sir, for example, let me take a simple example of e-way bill, which has been dismissed by the first appellate authority on a e-way bill documentation, whatever it is. So their quantum was around 8 lakhs or something. So they have
So
gone for
8,000 rupees.
8,000 rupees.
8,000 rupees.
So okay, that's what I'm saying. So in addition to that, he ended up paying all that 8,000 rupees also. So it can be say, I'm just trying to say, is it not costly? That's what I felt, sir. Or is it reasonable? That was because today we are going for advanced ruling and we are coming out with 20 issues there and 20 issues are discussed too. That is a different aspect. I'm not comparing the appellate or this advanced ruling with appellate tribunal, but just trying to look into the quantum of fees which has been decided there and which has been decided here. I felt like this was little. I understand that even High Court also collected fees, all that. But this was little something. I was just looking onto that aspect. So, might
See, I feel filing fees in the tribunal is good to have
Hmm.
because filing fees is, let's say, 50 rupees.
Hmm.
Then taxpayers will think that he should not spend more than 50 rupees. ಏನ್ ಮಾಡಿದೀರಾ ನೀವು ಬರೀ ಫೈಲ್ ಮಾಡಿದಿರಲ್ಲ 50 ರೂಪಾಯಿಗೆ ನೀವು ಯಾಕೆ 50,000 ರೂಪಾಯಿ ಫೀಸ್ ಚಾರ್ಜ್ ಮಾಡ್ತೀರಾ? Those questions will arise.
Okay.
There is some thinking over the years about the justification for having court fees. Why should there be fees for a court, especially in a civil suit?
Okay, sir.
So therefore, there is it operates as a deterrent for frivolous litigants, people who simply file appeals, etc. Those kind of situations. Or if you say the quantum is more, then it is subjective, but there is a thinking behind having a fees. How much can vary, but whether there should be fees, there is a thinking.
Okay.
Madam, just one point to discuss here. Like, let's say the demand is CGST 10 lakh, SGST 10 lakhs. The total demand is 20 lakhs. So the filing fee would be 10,000 plus 10,000, correct? No?
Yeah.
So both has to be, I mean, the word used there is tax. 110.5 uses the word tax.
Yes.
So that we,
That's why in this fee schedule also, they said whatever has been referred in the rules, that will be the fees for that. So I think when they are going to define the quantum of fees, it is based on the taxes.
yeah, see, okay. It is not 1,000 on 20 lakhs. I mean, it is not 20 and 20, right? It is 10 plus 10 only in the example I took up.
10 plus 10, correct. That is my understanding. 10 plus
Yeah.
10.
Yeah, so
Not
1,000 on
20 plus 20,
CGST tax,
yes.
1,000 on CGST tax, 1,000 on SGST tax separately to be computed.
Yeah, 1,000 per lakh actually.
Yeah, per lakh of CGST tax and
Even for IGST also it is 1,000 per lakh.
but
We have to 1,000 per for IGST. You are saying it will be like 20 lakhs demand, so it will be 20,000 only. No?
Same, 1,000.
Only, yeah. And one more here, they are just trying to say that all relevant documents, including, shall be clearly legible, duly paged, indexed, and tagged firmly. So I think it means that even if you are going to file the online appeal, there will be a requirement of filing the manual appeal also, and all that procedure they are trying to add here. I think initially they might say that file online and also file manually, though that has been removed for first appeal. But I think practically we are able to see that they're asking to file the appeal which has been already filed with manual documents also. I think similar practice may be there for just that procedure also. Then we are coming out with all this endorsement and verification. So here also one more issue which I'm just trying to look here is at the foot of every appeal or pleading along with all the relevant documents, they shall appear the name and signature of the authorized representative. So this also one something, because already there is a given an option to sign or not sign. But again, 22 is giving something that they shall appear the name and signature of the authorized representative. Is it only the authorized representative of the company who is going, or authorized from the respective entity, or is it authorized legal practitioner or tax practitioner or whoever is going to represent the case? So this is also something thought upon, because it is contradicting to the earlier rule. That is what I'm just trying to bring out here.
What's the question, madam?
So really ಏನ್ ಹೇಳಿದ್ದಾರೆ, at the foot of every appeal or pleading along with all the relevant documents, like whatever the supporting documents we are going to enclose here, they say that they shall appear the name and signature of the authorized representative.
Hmm.
So what I'm trying to say that earlier rule which we read, Rule 20, where they have given the option for signature either to a taxpayer or to the respondent or the applicant or the authorized representative. Whereas Rule 22 is trying to give that it should be signed at the foot of every appeal or pleading, they have said. So
See, if appeal has been signed by the authorized representative along with the appellant, then both will affix their signature in the appeal.
okay.
But and if taxpayer alone has filed the appeal, then appeal can be filed without an authorized representative also. So in those cases, that authorized representative signature will not be applicable. If authorized representative is appointed, then he must also sign. If he is not appointed, then only taxpayer will sign. But this is a case of even pleadings.
Okay.
Subsequently, if any papers are submitted to the tribunal, it cannot be some paper that came from the air. It has to be signed by the person giving it to the tribunal to rely on it and act upon it. Either taxpayer should sign or authorized representative should sign if the tribunal has to act upon it.
Okay. Because I was reading this and also, sir, little bit to be very specific. Here they are saying that every appeal or pleading shall be signed and verified by the party concerned in the manner provided by this rule. So that rule is giving a reference of Rule 20. And this was little going this. They would have said here by the party concerned or the authorized representative in the manner provided by the rules. Rather than bringing out this para was my thought, sir, actually.
See, Rule 20 refers to the appeal, not to the pleadings.
Okay.
Correct, no? See, there could be a representative change before the hearing.
Yes, sir.
Somebody else may or may not have signed. Subsequently, if something is being introduced, needs to be signed by the representative or the party, depending on what.
But sir, but whether authorized representative is not taking the risk of signing the appeal documents by endorsing, saying that he signed with accepting all the facts.
See, it's a matter of practice hygiene. Who wants to sign the appeal memo? Who doesn't want to sign the appeal memo? My suggestion to everyone is don't sign the appeal memo. But still, there's a tendency for signing the appeal memo. I have also followed it. Registry will say, who is the representative? Where will I send the correspondence? You should also sign it. All these things, the office will raise objections.
Yes, sir.
the larger purpose why one should not sign is different from the format that has a place for the AR to sign. But if after it appeal is filed and something further is being submitted, it cannot be unsigned document.
Okay, sir. Now, next is this translation of documents. We have seen in few of the instances, either in different parts of the country, that they are issuing the order in a local language. Even in few of the instances in Karnataka also, we have seen that partly the order is in Kannada and then something they come out with an English conclusion.
ಯಾವ್ದು SMR order?
SMR ಇಲ್ಲ ಸರ್ ಒಂದು ಇದು
No, no, but tribunal SMR or first appeal? First appeal in Kannada?
First appeal is in Kannada. Not first, yes, sir. First appeal is in Kannada. What in that Kannada, how it is that they have taken the report of enforcement report, which was in Kannada. So that has been pasted in this first appellate order to the extent of bringing out the facts of the case. In the order, the conclusion order is in English, sir, but wherever they have to extract the facts of the case, we are aware, sir, many times they do the copy paste of whatever we are giving them reply or whatever the facts of the case is there. So in that copy paste, they have copy pasted the enforcement report, which was in Kannada, and then they have concluded the order in English. So many times we see that few of the
Madam,
Hmm.
are you saying that the order is in Kannada or it is in English?
Order is in English, but few of the facts are pasted in Kannada, sir.
So it doesn't make it a Kannada order, alva?
So that's what I was just trying to bring out, whether that translation should be done for that also, or is it the purely, if it is a Kannada order, then it has to be done. Because in North India, I've seen, sir, in few of the states with the local mandate, they say that it has to be in a local language, and then if required, it can be translated in English. In few of the states where we are able to look into that, sir.
No, I didn't understand what your
So,
recommendation.
like Rajasthan, for example, I'll just give an example. In Rajasthan, the officer doesn't know English, so he will try to pass it out the order in Hindi, sir,
In first appeal.
in first appeal. So in that
First appeal
case,
order in Rajasthan is in Hindi.
yes, sir. So
Okay.
in that case, because few of the officers are not well versed, and it's a issue of translation, I understand, sir. But in that case, should this Rule 23 will be applicable, because they are trying to say that a document, even it may not be the order also, it can be even the RUD also, sir, relied upon documents where few of the orders will be in the local language. So in those scenario, this Rule 23 is trying to bring out that a document other than the English language intended to be used in any proceedings before the appellate tribunal shall be received by the registry, accompanied by a translated copy in English, which is agreed or to be by both the parties or certified to be a true translated copy by authorized representative on behalf of parties in the case. So I'm trying to say that it may not be the order, it can be even the other supporting documents also, which will be in the local language. So that has to get translated into English, and it has to be attested and should be filed along with that piece. That is
No,
all.
but it is not something that we can read and move on. Tomorrow there will be objections about the translation itself. You understand?
Yes, sir.
The translation may be objected by the other person that the meaning conveyed in the translated version is different from the original version. Then the bench will have to read it in Hindi and decide. If they're anyway going to read it in Hindi, then what's the use of translation? This translation is unheard of. That is why we have state member who is supposed to, if documents are not in English and the bench feels that they are not able to proceed without assistance of local language, imagine directing a person to go and translate it. Who is the certified agency for translation? I'll go to my grandmother, ask her to translate it. Can I submit that after notarizing it? Isn't it? There is no civil type of centralized agency who is certified to do translation. People will do Google Translate and submit. So again, this is pasted from somewhere without thinking the seriousness of this.
Yes, sir.
You tell me any other instance where translation is mandatory? If a person signs a document written in a different language, then translation is necessary. If a person is acting upon a document prepared in a different language, but acted upon in a different language, then translation. We have state member, he should read Kannada. We have state member in Jaipur, he has to read Hindi. This translation is a very serious thing. There's no, they can't compel a taxpayer to translate. Advocate knows Hindi, client knows only Hindi. If you translate it, then we don't know what to explain to you. How can the procedure rules assume that everybody knows Hindi, English? If the source document is in one language, it is the tribunal's responsibility to understand it and do justice.
Okay.
Because this translation has not been given much thought at all in drafting these rules. And they should say, and the translation shall be by an agency of IIT Madras, something they should say. Translation won't be readily accepted. We'll file Kannada only. Like you
Yes,
said rightly, half of it is in Kannada, half of it is in English. Now, who is going to translate what half, and how is the connection made between the translated half and the original half?
correct. Yes, sir.
Again, this is
Got it.
also not something that was given thought and munduku.
Yes.
But very
Def-
serious issue, translation is.
Yes, sir. And they further say both the parties should agree in this.
All parties should confirm, yes.
Yeah.
ಬಿಡ್ತೀವಾ? All right, please.
Now, coming to this rule 24, endorsement and scrutiny of petitions. So again, they are saying if there's any defective, whenever this appeal has been filed, then they will issue a notice, and within 7 working days from the date of return, the same shall be placed. So that has to be rectified. But here they are trying to say endorsement and scrutiny. Why they have used the word petition, sir? Because there is no reference of petition. This is for High Court. So this should be removed, is what I think.
ಕರೆಕ್ಟಾ? ಗೊತ್ತಾಯ್ತಾ? Copy ಮಾಡ್ಕೊಂಡು ಹಾಕ್ತೀನಿ ನೋಡಿ.
So this is the point. So it will be fine. Registration of admitted appeal. So once on admission of the appeals, the same shall be numbered and registered. So I think again this is the power of I will not go into the appellate tribunal. This all ex parte amendments, all what he is supposed to do. These all are the power of registry till calling for record. Should I look into this, sir? Like calling for records, all that?
No, this is a very serious issue. This rule 27, let me share some thoughts.
Yes, sir.
In VAT, when we go to tribunal, there are various orders. There is the order of original order, then there is a reassessment order, then there is a first appeal order,
Yes,
then there is an SMR order. There are
Yes.
4 files that have to be brought to the tribunal.
yes, sir.
Now, all those 4 files have to be submitted to the tribunal by the respective officers, not by the party.
Yes, sir.
You see here, on admission of appeal, the registrar shall call for records. It will take 5 years for all the 4 offices to send the files.
Yes, sir.
This rule 27 has to be deleted. This is a very bad rule. Please go to rule 24, madam.
Yes, sir. Here.
Not 24,
I think-
21. 21. If you see here, I have to submit all the documents at the time of appeal, which means I have filed the show cause notice, reply, first order, first appeal, order against that, then SMR order notice, SMR reply, SMR order. If I have filed everything, why I should file everything? Why they should call for copies later?
I
You
think that,
understand?
yes, sir. Yes, I think they have copied this from this VAT tribunal procedure, sir.
No,
I
no,
think.
everything is copied part by part, for some from High
Hmm.
Court, some from
Hmm.
the.
Hmm.
Therefore, Rule 27 is extremely dangerous.
Yes.
In VAT tribunal, if you see, this is a big cause for delay.
Yes, sir.
In place of 27, what we require is concept of paper book. Whatever I want to rely upon, I will place it on record. If
Hmm.
department thinks I have enclosed a wrong show cause notice or wrong papers, they can object.
Hmm.
They have included calling for records, but they have not included paper book.
Okay.
Isn't it?
Yes, sir. And
Therefore, yes.
yes, sir. Sir, one more point is, they are also trying to say that if so directed by tribunal, but this was not there in the bar tribunal, because there it was mandatory that they have to call for the records, and then only they used to conduct the hearings. But now I think something, I don't know what is the intention behind this rule, but I'm just trying to think. Only in cases where the tribunal feels that there is a requirement to verify the documents of the respective, what I can say, adjudication or SMR, or as the case may be. So something can we look that aspect also, sir, because that is little different from what we were doing for VAT.
You're right, you're right.
So I think this is one more we can look onto that aspect. And now the second is production or authorization. Production of authorization for or on behalf of an applicant or respondent or the party. I don't know why again they have used the party, because party includes both applicant or respondent. That is a one aspect. And here they are also trying to say that when an appeal is to be instituted for behalf, who again they are trying to bring out, who signs or verifies the same shall produce along with such appeal for verification by the registrar a true copy of authorization letter empowering to produce such further material. So I think it is kind of a power of attorney they are trying to bring out here, Nasir.
You're right.
Mm.
But then what happens? This rule 28, maybe it should have been better worded, but is required in case the different advocate is brought on record.
Mm.
Suppose I have filed appeal, then Annapurna madam, you are appearing, then we have to have a
Yeah.
system where my name has to be removed from consultant on record and your name should be included.
Yeah, that procedure is missing here, sir, actually.
Correct. That is what should have come in 28.
Yes.
And look at it. Why is 20? See the placement of 28. It should be in one place where registry should do certain things regarding a review of the file.
Hmm.
Yeah,
It is already there, sir. Already there, sir.
Correct.
Already there. Again, they have repeated here again. Then again, 20 is IA. We will deal in detail later. There is a specified form of one and all that requirement. We'll deal later on that IA part. Then we are coming with this procedure on production of defaced, torn, or damaged documents. So again, I think here they require a separate, I think in that index only they have to specify what are the documents they are defaced, torn, or anyway damaged to be made by the party producing in the index, whatever index we are preparing in the pleading, and it should be verified and initiated by the officer authorized to receive the same. So this is also something a little specific, sir. Then we have Rule 31, which is on additional grounds in the appeal. I think whichever were not set forth in our first appeal, I think it is again the discretionary power of the appellate tribunal to give the permission for that additional grounds with a sufficient cause. But if we read this Rule 31, they are saying that grounds which may be taken in appeal, though, shall not, except by the leave of the appellate tribunal, urge or to be heard in support of any grounds not set forth in the form of appeal. But the appellate tribunal, it deciding the appeal shall not be confined to the grounds set forth in the form of appeal or those taken by leave of the appellate. So shall not restrict decision on any other grounds unless the party who may be affected has been given a sufficient opportunity of being heard on that ground. So this is as this is the last fact-finding authority. So I think the tribunal has been given the power to accept this additional submission and additional evidence which has been given in subsection 111 subsection 2, sir. So only thing is, I think again it goes with the discretionary power of that appellate tribunals, because and there should be, even the section also says that there should be sufficient cause for giving the additional grounds as such.
Right.
Then rejections or amendment of form of appeal. So here they are just trying to bring out that the power has been given to either reject that appeal, or if it is a defective appeal, then they can give a notice to rectify the defect within, I think here they have used 7 days, but here they have stated not exceeding 30 days. Earlier rule we have read, na, sir, that they will give that registrar will issue the notice for rectifying the defect. That was 7 days, but if we in rule 21, but here again they are saying that it should, which may in case not exceed 30 days. So this is something, 7 days and 30 days is there for correction of that amendment or defect, whatever as the case may be. And the registrar may reject the form of appeal if the documents are not produced or the amendments are not made within the time limit.
Hmm.
And I was also trying to see, sir, like they are using the reference of precedent also in few cases, which I was founding that how can a main discretion authorize any officer to return any form of appeal, allow the documents to be refiled. So I think internally they will have that instruction, sir.
Mm.
I think that is what I was just trying to, because that power will be given through instruction to the officer, and accordingly they will execute those powers. So this is what, but we have to look who will be the officer of the appellate tribunal. That we have to see, like internally they might have that, what I can say, jurisdiction, different levels of officers who can exercise those power. Then may not be restored to it, so unless the bench allows to be restored. So again, this restoration is also, I think I did not experience anything as such as restoration of appeal, sir. But here I am able to see that there is something which they are trying to bring out, that but the appeal or application may not be restored to its original number unless the bench allows it to be restored on sufficient cause being shown. So once it is rejected, they are also trying to bring out on restoration of appeal.
Hmm.
So I have not experienced as such, sir. So I thought I was just thinking might be something which they are trying to bring out here is
Hmm.
the one aspect which we have to look here. And who may be joined as respondent. So I was just trying to look into the power of the officers which has been given, and just trying to see here they are saying in an appeal or an application filed by a person other than the commissioner, then the commissioner consent shall be made the respondent to the appeal or the application. And in an appeal on an application by the commissioner, the other party shall be made. So is it that the commissioner will be a respondent, sir, or will it be a this joint commissioner appeal, sir? Actually, it will be.
No. The executive commissioner only is the respondent.
Okay.
Commissioner appeals will not be respondent.
Okay.
There are some interesting,
Hmm.
soon after constitution was promulgated,
Hmm.
one writ petition was filed in Kerala.
Hmm.
Was filed in Kerala High Court. They did not know who to make the respondent.
Hmm.
So at that time, they filed the writ petition with the chief minister of the state as the respondent. If you search, you'll find something
Hmm.
versus K. Karunakaran.
Okay. Okay.
They filed the writ petition against, it was a habeas corpus. They
Hmm.
filed it writ against the chief minister because he is the highest officer. That's when they realized that who is the respondent is a very important aspect, and tribunal can give directions to whom, that decides who should be the respondent. So commissioner is the highest ranking officer in the state.
Hmm.
He is the one who delegates power under section 5. Therefore, commissioner, although assistant commissioner has issued order,
Hmm.
it is acting, assistant commissioner is acting as a delegate of the commissioner. Therefore,
Hmm.
respondent should always be commissioner.
Okay. Then we are coming out with this rule 34. I think again this is like all this, a copy of each along with the relying document shall be provided by the respondent as the case may be as soon as that. Okay. This is again then filing of form of cross objections, applications or replies to appeals or applications. So I think the time limit which they have given for appellant and respondent, it shall be, they have just specified that whichever is prescribed in the rules accordingly, they have to file. So it is APL 6, which has been prescribed, and it has to be registered and numbered. So I don't find anything as such, sir, here. It's specific because APL 6 I think that April 6 is for both taxpayer and I think for department, I think they have to make a separate application. Then filing of reply and other documents. These all are the communications which has to be made after filing the appeal. And each respondent may have to file his reply. Again, the terminology is petition. It is not petition, it is to the appeal or the application copies either in person or through an authorized with the register. So this is again the functioning and copy of such reply should be served on the applicant by the respondent. So whichever is being filed, all that communication between the department appeal and notice to be issued to the appellant, I think all that procedures, they have tried to add it in Rule 36. So if the appeal is filed by the applicant, then the notice will be issued to the respondent and accordingly they have to file the reply against that notice. Or if the appeal is filed by the department, then the notice will be issued to the taxpayer to file a cross objection and accordingly they have to file the reply. Fine, sir. I think that is what they are trying to bring out here.
Correct.
Then filing of rejoinder is there in Rule 37, where the bench is allowing to file a rejoinder with an advance copy to be served upon the respondent within 1 month or such time as may be specified or extended by bench. So I think I don't know how it will be because again it will be through Gestat portal.
Correct.
So so I think I don't know how it will be served because I'm trying to say that it will be based on like serving will be again we have to refer 169 served upon the respondent within 1 month or within as may be specified or extended by bench. So again that power has been given to the bench to extend that time limit also. But if you see, sir, like whatever I'm able to see that condonation that extended 3 months. Earlier there was no time limit, sir. I think last year they made an amendment for a condonation of extended 3 months. So I think that is something which they have given. But here they are just trying to say that where the respondent says such additional facts as may be necessary for the just decision of the case, the bench may allow the applicant to file a rejoinder to the reply filed by the respondent on Gestat portal. So I think even it will be online only.
No. This
Hmm.
rejoinder is a very different procedure from making synopsis submission. Rejoinder can be objected.
Okay.
So therefore, where is the provision for filing rejoinder in the Act? You
I
file
agree.
appeal, that's all. This is without a reference in Act.
Correct. And there's no such form also which has been specified.
Correct.
Nothing as such, yeah. Yes, sir. Shall I continue, sir? Is it fine with everything?
Yes.
Yeah, right. Then we are having now the issue is cost list. I think this is again few of the sections are pertaining to the power like how they have to prepare and publication of this daily cost list, which we are able to see. And that will be prepared. There is a specified form called as CDR1, which will be pasted. That's what I'm able to see on the notice board of appellate tribunal. And also it will be there in the portal before the closing of working hours on each working day. So for example, if it is tomorrow, then the cost list will be as today the practice is followed. I think similar practice they are trying to follow here also with this pasting by the end of the days. Right, Nasir?
Yeah.
So
Correct.
this is what, yeah. Then subject to the direction of the president, listing of cases in the daily cost list shall be in the following order, all that clarification, admission. So I think this is the sequence they are going to follow when they are going to prepare the cost list, like whether it is a pronouncement of order or clarification or admission or rectification of defense or past heard cases or for numerical order, whatever it is. There is a sequence which has been given for preparing the cost list, and that cost list will be communicated to all the parties with the date and place of hearing of the appeal. And the title of the cost list shall consist whether it is a like what is the day, date, and time of the sitting bench hall number and quorum indicating the name of judicial members and technical, which we don't find it in today, sir. We don't find this. We get this date and sitting hall, but we don't get the quorum whether it will be a single or judicial. This I think is not necessarily existing.
Correct.
So this is
So you'll get
we'll get like judicial member and technical member. Will they add that, sir? Because whether they are
the
there or
quorum
not.
will be specified in the cause list itself.
Huh.
It will not be unknown.
Okay. Yeah, but what I was just trying to say that, for example, if they are specified and if he is absent like for the next day, that is not there, like something which, like for example, tomorrow they say that there's a technical bench and judicial member, but if one of the member is absent, that is not added. So many times we see that when we see that quorum is not there. So, but here they are just trying to say that quorum indicating the names of the constituting the bench. So I think names will suffice whether they are absent or present. Okay.
Hello, I didn't understand. But
Answer? Answer?
I didn't understand.
No, sir, what I'm trying to say that they will prepare a cost list by the end of the day with the
Right.
indication of the case and with all that hall number and all the names also of the judicial member and technical member.
Right.
What I'm trying to say that sometimes we are able to see that that judicial member or technical member is absent.
Okay.
So that details we are not finding in the cost list. So I was thinking something they are trying to bring out here, but nothing as such. It is the
No,
same.
hello, if cost list is published,
Hmm.
now he is absent. ಏನ್ ಮಾಡ್ಬೇಕು ಇವಾಗ?
ಇಲ್ಲ ನಾನೇನ್ ಅನ್ಕೊಂಡೆ ಅಲ್ಲಿ ಲೈಕ್ ದೇ ಶುಡ್ ಸಿಂಗಲ್ ಬೆಂಚ್ ಆರ್ ಡಿವಿಷನ್ ಬೆಂಚ್ ಇದು ಜುಡಿಷಿಯಲ್ ಮೆಂಬರ್ or ಟೆಕ್ನಿಕಲ್ ಮೆಂಬರ್ absent ಇದ್ರೆ that information is not passed on. Only when they go to that bench they get to know that he's absent or the quorum is not there. So something that information would also got added ಅಂತ ಅನ್ಸುತ್ತೆ ಸರ್.
Okay.
ಇದು ಕರೆಂಟ್ ಇದ್ದಲ್ಲಿ ಇಲ್ಲ ಬಿಕಾಸ್ ಈವನ್ ದ ಕರೆಂಟ್ ಆಲ್ಸೋ ಫಾಲೋಯಿಂಗ್ ದ ಸೇಮ್ ಥಿಂಗ್ ಬಟ್ ವಿ ಹ್ಯಾವ್ ಸೀನ್ ಮೆನಿ ಟೈಮ್ಸ್ ದಿಸ್ ಇಸ್ ಹ್ಯಾಪನಿಂಗ್ ಎಸ್ಪೆಷಲಿ ಇನ್ ವ್ಯಾಟ್ ಟ್ರಿಬ್ಯುನಲ್ ಅಂಡ್ ಈ ತರ ಇದ್ದು ಸೊ ಆ ತರ I was thinking that also they can bring because they will definitely publish by the end of the day only. So at least they will be aware of that. Then against the number of each case listed, the following shall be shown: name of the legal practitioners as if it is already set out in your appeal form, and name of the parties if unrepresented with the rank in brackets. So this is what it is. And a new cost list and adjournment of cases on account of non-sitting of an appellate tribunal. So if by any reasons does not function the day, then again they will prepare on that day. The new daily cost list shall be prepared for the cases listed for the day. Is cancelled for the reason of inability, then adjourn the case is posted. So this is the common practice which is there. So same thing they are adding here. Then any notice or communication to be issued may be served. So here they are very specific. They have referred 169. It has to be served as specified in 169. And for
I
the
have a
purpose,
small doubt here.
yeah,
Like, in terms of the members sitting, currently, the current appellate tribunal also, the members are not sitting many times. So is there anything that the SSC can do, like file an application or something, or is there any power there for the SSCs?
no, nothing. That's what, there's nothing as such. We have to base it. We have to represent there. If he's there, we have to hear the matter. Otherwise, the date will be adjourned.
Yeah, so there are like multiple months together that the members are not sitting currently. So I was wondering if the SSCs have any power to make them function, basically.
There's nothing as such. We don't have, that is what they can pray. There's nothing as such, I believe.
Okay, okay.
And here they are trying to say that common portal shall mean the GSTAT portal. So wherever they have referred the common portal, which we already have this GST portal, and along with that, there is also a GSTAT portal. So they have just tried to incorporate the GSTAT portal in the definition of common portal. Then we are coming to, is there anything here to be discussed? And only they are just trying to say that, and their appellate tribunal may, after taking into account the number of respondent and their place of residence or work or service, so many they could not be affected, direct that notice of the petition or application shall be served upon the respondent in any other manner, including the manner of substituted service as it appears to the appellate tribunal just and convenient. When 169 is there, I was not able to come out that notwithstanding anything contained in subrule 1 and 2. So they have come out with the other powers also where they can even serve upon the respondent in any other manner in addition to the manner which is specified in 169. They are also coming out with any residual manner also, which we have to wait and see how it is going to be convenient because of substituted service as it appears to the appellate tribunal just and convenient. And anything, sir, here? I am not able to think on this much here. So notice shall be served, same thing, in any other is to accept a notice or such service shall be deemed to be a proper service. Anybody has anything to be discussed here? Hello? Hello?
No, ma'am, nothing from.
Okay, I'm audible, man, that's. So even if it is uploaded in the portal also, it's still service of notice, and so basically they're trying to bring into, but I'm not able to look much on this rule 40 subs rule 2, because I feel that 169 is very widely covered all the mode of communication. Or I think even like if it's not accessible, something WhatsApp can also be brought out here in 40 sub rule 2. Hello.
Yes, ma'am.
Yeah, I'm able to. Anything else here, or shall I proceed?
Yes, ma'am.
We will take up to chapter 5 today and then we'll see. Venu, you are there? Hello.
Yeah, Venushwar is there, ma'am. I suppose he's mute or yes.
Yeah, I can continue now. That's what.
Yes, ma'am. Yes.
Annapurna, one doubt on rule 38 sub rule 2, where they are listing the matters in the order of priority. Second thing, they have listed cases for clarification. So
Where?
what get a second matter? First is cases for pronouncement of orders, and second is cases for clarification. So what gets covered under cases for clarification?
No, what I understand is whatever the appeal has been filed, and if they have any issue which they are not able to understand from the grounds of appeal or the supporting documents, and if they have further query on that issue, then I think they will fit it for clarification. There is a further discussion required on that case actually. So further evidence or further verification or further information. So I think those cases will be listed for clarification.
Okay.
Yeah. So now we have this rule 41. This is like a hearing of the appeal. So there is a fixation of date on which they are going to hear the appeal, and or it can be adjourned with the application made by the applicant or the respondent as the case may be. So this is not much to be discussed. Then next is rule 42, where action on appeal for appellate's defaults, and if the date is fixed for hearing and there is some hearing dates are given and it may be attended, the appellant does not appear itself, then the appellant tribunal either they have the power to dismiss the appeal for default or not appearing, or hear and decide it on merits. But where an appeal has been dismissed for default and the applicant afterwards and satisfied that there was sufficient cause for his non-appearance, then the appellate tribunal shall make an order setting aside the dismissal and restore the appeal. So earlier rule also we were referring on the provision for restoration of appeal. So this is a situation where you can restore the appeal if you are able to produce a sufficient cause for not personally attending the hearings of the case. Hello. Hello.
Yes, madam.
Yes, sir.
Good.
Yes, and then they also have the power to pass the ex parte order where the applicant or the appellant or the respondent is not appearing for the hearing, then they can decide the ex parte order also. So this power has been given to them. And again, we are able to see that there is a rule 44 where they have given the power to continue the proceedings even after the death or an adjudication as an insolvent of a party to the appeal. So in case if the appellant or the respondent dies or is adjudicating as insolvent, or there is some companies, their firm is dissolved or the company is liquidated. Even in that case also, unless application is made for continuance of such proceedings, as the case may be, if there is an application, if it is made that they have to continue this litigation, subject to that what liquidation or dissolving of firm. In that case also, I think they can continue the proceedings. But I think this is also going to
Where
be.
is the provision in the act?
Yeah, so that's what I wanted to. There is nothing as such which they can do it as such, because there is a separate sections which they have defined for this case of insolvency of a company or a death of a partner, where they have given a different power as such in section 90, 91, 92, 93, all that. But still here the rules is overriding the section what has been given in the GST Act. And they said that even after the death or adjudication, they can still continue the proceedings.
Hmm.
So I think this is something overriding the section what I feel, sir.
First, then copy paste.
How to say.
Right.
Then, and they also have given the time limit, like within what period you can give all that they have defined. But anyway, we have to wait and see how this is going to get. But I think this will be removed, but they cannot bring out some procedure which is beyond the provision of the law. Now, this is more important, sir, this production of additional evidence, what I think, sir. Because here they are just trying to say that the parties to the appeal shall not be entitled to produce any additional evidence, either oral or documentary, before the appellate tribunal. There's a separate section also and rule also which has defined in what scenarios they can they can ask them to produce the additional evidence. But if we read this rule where they are trying to say that if the appellate tribunal is of the opinion that any document shall be produced or any witness shall be examined or any affidavit shall be filed to enable it to pass orders, or if adjudicating authority or appellate or revisional has decided the case without giving sufficient opportunity to any party to adduce evidence on the point specified by them or not specified by them, then the appellate tribunal may, for reasons to be recorded, allow such documents to be produced or witnesses to be examined or affidavits to be filed or such evidence to be adduced. So what they are just trying to say that in case if the earlier, in case of your adjudication or during your first appeal, if you have not been opportunity to produce your evidence and you have to prove that there was no opportunity which was given, then in that case, they can, you can produce the additional evidence before the appellate tribunal. And it can be done either before the appellate tribunal or before the authority as the appellate tribunal may direct. So sometimes you can produce even before the registry also, no, sir? I think before either during the hearing or before that also it can be produced. And where any direction has been made by the appellate tribunal to produce any documents before the authority shall comply with the direction of the appellate tribunal, and after such compliance and the documents record or deposition of witness or record of evidence adduced to the appellate tribunal. So I think this is a power only which is given to the department, not to the appellant. Because the authority shall comply with the direction. So this rule 45 sub rule 3 is applicable to the department, to wherever they direct to produce a document, then it, but when we have for a call for records, I don't know why this is required, I think.
Correct.
Yeah. Then rule sub rule 4, we have that the appellate tribunal may on its own motion call for any documents or summon any witness on point at issue if it considers necessary to meet the end of justice. So this is what is given. Then whatever the evidence they are giving, it has to be given by way of affidavit. It cannot be just produced in a plain paper. It has to be notarized and it should be by affidavit. So they're just trying to bring out here. So notwithstanding all that necessary cross-examination, conflict with the here one more point I have, sir. Here, like they are saying, where the appellate tribunal consider is necessary in the interest of natural justice, it may order cross-examination of any deponent on the points of conflict, either through information and communication technology facilities such as video conferencing or otherwise, as may be decided by the appellate tribunal on an applicant moved by any party. What can be the scenario, sir? Here, this one, like I was just.
No, in case there is any officer who has to be called for an examined, etc. ಇದೆಲ್ಲ ದರ್ಶನ್ ಬೇಲ್ ಕೇಸಿಂದ ಕಾಪಿ ಮಾಡೋದಮ್ಮ.
Okay.
ಇದೆಲ್ಲ or POCSO ಅಲ್ಲಿ cross examination in video camera ಇಲ್ಲ. So they brought this. Statute ಅಲ್ಲಿ ಇಲ್ವಲ್ಲ ಇದೆಲ್ಲ.
ಅದೇ that's what I was just trying to say. It was not able to connect with any of the provisions.
ನೋಡಿ ಬಡಿ ಮಕ್ಳು ಏನ್ ಮಾಡ್ತಾರೆ.
Okay, yeah. Then adjournment as such teams, I think the section is saying only 3 times they can adjourn the appeal, like they can go for adjournment.
Correct.
Then proceedings to be open to the public is stage of the any public generally or any particular shall or retain the room or building. So they have the discretion. Generally, anybody can sit and listen the case. It's not like that. It is open to the public, but there are few cases, few reasons, few places, few persons. They might come out saying that only it should be access to a limited person and limited particular person, and it should not be open to the public.
ಇಲ್ಲ ಒಂದ್ ನಿಮಿಷ ಏನ್ಮಾ it should not be open to public.
Yeah, it is open to the public, but only at any stage they think that case that public generally or any particular person shall not have access to. In that case, they may not allow them to attend the proceeding, sir.
See, the whole idea of justice delivered in a public forum is that the bench will act in a fair manner. That is exactly the reason why first appeal and SMR orders are not fair, because privately they will sit and do something. In fact, 248 should say that the operative portion of the order must be pronounced in open court. It is taxable, it is not taxable. And the 4 ಜನದ ಮುಂದೆ judge should mention. If he tries to go into something else, because you don't know, because the whole practice of reserving for orders, they will say something. They'll hear everything and they'll say reserve. They'll quietly go in the room and write some order in which nobody knows. So 48 is a safety valve against any improper application of law in tribunal.
Okay, sir.
Yes.
Then procedure for filing of and disposal of IA, again they have come out. Then appeal referred to a larger bench. So in case of different opinion of member of bench while hearing an appeal, the appeal shall be referred to a larger bench by the president as it deemed fits for disposal of the appeal. Here I have a issue, sir. Like if there are 2 state benches in Karnataka, just for an understanding, sir. Then if the Bangalore bench and say Hubli bench, we have 2 benches in Karnataka. Let us presume, as on date it is not there, but let us presume there are 2 state benches, and if there is a difference of opinion in Hubli bench, then I think it will be referred back to a Bangalore bench, right, na sir? Then if there is only we have a single bench in Karnataka, say Bangalore bench, and we don't have any other bench, and if there is a difference of opinion in Bangalore bench, then it will be going to other state as may be decided by the president. Tamil Nadu, yeah. Now, in case of different opinions of member while hearing, the appeal shall be referred to larger bench anta helidare. So this is something I was not able to understand.
No, what they will do is that's the difference. In the act, it talks about referring to a third member. Larger bench is where all 3 are sitting. Where the party gets to present before a 3-member bench or a 5-member bench. The act does not talk about constituting a larger bench. Act talks about reference to a third member. Alva? So again, copy paste.
ಅದೇ ಅಲ್ಲಿ ಹೇಗೆ ಡಿವಿಷನ್ ಬೆಂಚ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಬೆಂಚ್ ಸೊ ಸಮಥಿಂಗ್ ಲಾರ್ಜರ್ ಬೆಂಚ್ ವಿತ್ ಮೋರ್ ನಂಬರ್ ಆಫ್ ಮೆಂಬರ್ಸ್ ಐ ಥಿಂಕ್ ದಟ್ ಈಸ್ perspective for high courts and Supreme Court, but I think here it should be a third member and not a larger bench.
Correct.
Then order to be signed and dated. So here they are just saying that it should be signed and dated by the members constituting the bench. So the respective member, whoever is there, he should sign that. And last date of hearing shall be typed on the first page of the order. And if the order is dictated on the bench, the date of dictation should also be there. If the order is reserved, the date of final order will be the date on which the order is pronounced. And wherever the gist of decision is pronounced without a detailed order, the last part of the detailed order shall specify the date on which the gist of the decision was pronounced. And in such cases, the date of the final order shall be the date on which all the members of the bench sign the order. And where the order is signed on different dates by the members of the bench, the last of the dates will be the date of the order. So it depends upon, we have to check the dates signed by all the different members of the bench, and the last date should be the date of the order. irrespective of when it is served, right, Nasir?
Right.
Then publication of the orders, it will be like orders of the appellate tribunal as are deemed fit for publication in any authoritative report or the press as may be released for such publication on such terms. We don't have such things for first appellate, Nasir. This is only given to tribunal. Alino Kodbek actually. It will really help. And I had read somewhere that if the one member is like not signed, then again they have to rehear the matter, something. I don't know. Somewhere we'll see in the next, I think, next part, somewhere they have given on that. We'll see on that aspect also.
Alright.
So I think, should we take the next part, sir, in the next session? Shall we do that?
We will take with.
And whatever changes we have to supposed to make, I'll just add it up in this PDF format, sir, and share it once it is.
All right.
We'll continue to the next week also, madam.
Is it fine with everyone next Tuesday? Is it okay?
It will go in a go and we'll complete it.
Yes,
Okay,
okay for me.
okay, then we can.
Done.
Okay, sir. Thank you, everybody.
Thank you so much.
Thank you.
Thank you, ma'am.
Bye.
Thank you.
Thank you. Thank you.